for recreational purposes. In that same provision, a minor is prohibited from betting. So this is really to say that this is a family sport, but underage minors will not be allowed to bet, but they can certainly be on the premise to be able to enjoy the day's entertainment. Section 37 of the Act is amended in the bill to stipulate that a person on the prohibition list cannot enter the gaming establishment or place wagers or collect winnings approved by the board. If a gaming operator allows a person on the prohibition list to enter and place wagers or collect winnings, the gaming operator will be liable to a fine not exceeding $50,000. The offense of obtaining a license by deception or fraud under Section 40 of the Act is modified to include the offense of providing materially inaccurate information. The provision of the broadcasting arrangement, Section 44B of the Act, is amended to allow a racecourse operator to enter into the broadcast arrangements or commercial arrangements and to approve other persons to broadcast. At the same time, with the change is made with respect to the amendment to Section 44C of the Act, use of a racing information, as a racecourse operator can approve the use of such information and not the authority as previously approved under that section. I think it's good for me to be able to make that distinction, is that there's going to be a racecourse operator which establishes rules for the racecourse, but the regulatory agency is concerning itself with regards to the betting. So the integrity of the betting, that in terms of doping, blood tests, and meeting international standards. So that's the difference between the two people. Section 44D of the Act, which provides for interference with license and rules of racing, has been strengthened, and it now provides for interference of a racecourse operator, betting provider, and an official performing a function under the rules of racing or rules of betting. Swindling and cheating are prohibited through the insertion of a new section in the Act, Section 45A, in relation to the exclusion of persons from the racecourse operator or betting provider from internationally permitting a person named in a list to enter or having entered to remain within the racecourse. A new section is added to the Act to permit a license to issue a sub-license to conduct gaming or betting in multiple locations in St. Lucia as provided by the board. So it means that the operator can appoint outlets in St. Lucia to be able to take wagering or betting. The Minister of Finance is authorized through the amendment in Section 55 of the Act on the making of regulations to make regulations to prevent money laundering and other improper currency transactions, including implementation of the Money Laundering Prevention Act Cap 12.2. The Gaming, Racing and Betting Amendment Bill should be enacted so that the changes highlighted above can be made to the gaming, racing and betting, and to continue to strengthen the separation between the regulator and the operator, and certainly to be able to give us the ability to not only take wagering and gaming in St. Lucia, but to be able to offer the races that we're going to be having here for them to be played internationally, and that we can also now benefit from those bets being made internationally on the races in St. Lucia. As I said, Mr. Speaker, these amendments are coming to be able to strengthen and bring greater clarity in the Gaming and the Wagering Act. We will, at a later date, be coming to include now lottery as part of this overall authority. So the intention, Mr. Speaker, is to have one authority that will have three different acts that they'll be overseeing. So currently, I have to say to you, Mr. Speaker, the technical staff that we have that are providing the necessary oversight to the lottery machines and also the casino we have is willfully lapsed. And therefore, the intent here is not only in terms of creating a body of people, but also to strengthen the provisions in the Act to bring greater clarity in terms of what we think to be legal gaming and betting in St. Lucia. Thank you.
Honourable members, the question is that a Gaming, Racing and Betting Amendment Bill be read a second time. Honourable Leader of the Opposition.
Thank you, Mr. Speaker. Mr. Speaker, the this new bill will no doubt bring the Honorable Prime Minister closer to his dream of having horse racing in St. Lucia. I just want to make one or two comments, one in particular, Mr. Speaker, and I speak on the amendment of Section 20, which speaks to the deleting of subsection 3A and the change into another subsection 6A. And it says, and I read, apply if the denial, issuance, suspension, or limiting action occurred 5 years prior to the application and the applicant demonstrates by clear and convincing evidence of his or her rehabilitation. So what that speaks to is, I'm reading from the bill that was circulated, page 19. Amendment to Section 20. Amendment to Section 20. That's okay? And it deletes subsection 3A in the old Act 13.3, and then it includes subsection 3A spoke about a license being refused, and it adds section 6, a new section, subsection 6A, and it says, if there is a denial, issuance, suspension, or limited action occurred 5 years prior to the application, and the applicant demonstrates by clear and convincing evidence of his or her rehabilitation. So it means if you committed an offense under the Act, if after 5 years you've shown signs of rehabilitation, then you can be given back your license or allowed to gamble again. I'm not sure. But I just want to, if I can refer to the Act that deals with criminal records and the rehabilitation of offenders. And it speaks about, in Section 5, it speaks about rehabilitation periods. And it says for somebody to get pardoned, or they must have, if it's a non-custodian sentence, they must have 5 years. If it's a sentence, if they were sentenced to imprisonment for a term not exceeding 1 year, they must have 7 years without committing an offense. And if their sentence of imprisonment was for a term exceeding 1 year but not exceeding 3 years, they had to show rehabilitation for 10 years. Now, that is according to the Criminal Code of St. Lucia. Now, according to that Act, you only have to show 5 years. So I'm wondering whether these two acts should not be, whether these two provisions should not be the same, like the same provisions in the Criminal Code, whether it should not be the same in the Gaming, Racing and Betting Act. Why is it so lenient in that case, and in terms of the sentences and the rehabilitation periods in the Criminal Code so high? I don't know why is there such a conflict between the two acts. I should think that it should be the same, because in that act, it's easier for you to get rehabilitated. It's easier for you to get pardoned if you have an offense in gaming than if you have a regular offense in, and that comes to mind, the non-custodial sentence in terms of marijuana, 5 years, which is the same for gaming. So I'm wondering whether it should not be the same, and why the difference. Is there any special reason why that period of rehabilitation is shorter in terms of gaming than it is in terms of regular criminal activity in the country? There's one more thing, Mr. Speaker. I heard the Minister of Finance say something about revenue. I didn't pick up what he said, that there would be no revenue collected by the authority apart from something. I don't know whether you could clarify it for me, please. I didn't hear what he said. I don't understand what he said in this regard about the revenue. What is a revenue source for this board? I really did not hear what he said where that's concerned. So, Mr. Speaker, I said that is my short comment on that act.
Honorable Prime Minister.
Thank you very much, Mr. Speaker. I thank the member on the opposite side for his contribution. I would imagine that the reason for the difference in the time period is exactly as he outlined. One is in the criminal code and deals with convicted criminals, whereas we're dealing with the rules of the horse racing track. So I'm not so sure that if a person is found guilty of a breach in the rules of the gaming track, that's a criminal, would be warranted as being classified as a criminal, but certainly would be in breach of the rules of the entity. So I think to merge the two would not necessarily be sensible, given that the gravity of the infraction certainly would not be comparable between one being the rules of the game and one being in conflict with the criminal code of St. Lucia. In terms of revenues, I don't remember making any reference to any revenues. What I've indicated is that the Act itself is ordered to be able to separate the operator from the regulator, and that we're talking about dealing predominantly with the regulations as it pertains to wagering, which in itself is a money earner for all parties involved. And so the rates would be not in here. This would really just dealing with the day-to-day operations of the entity, and as I said, to making much clearer separation between the horse race track operator versus the people who are running the wagering. And so the state's responsibility is to make sure that all of the wagering that's being done in St. Lucia is being done to an international standard, and that people are being held accountable, and that there's clear separation between the people who are running the horse racing and who are going to be providing the gaming, that we're going to be the oversight of those entities. So a lot of the changes that were being made here are really definition changes, and to bring greater clarity to people's roles in being able to separate those separate entities. As I indicated, we're bringing the lottery in, and the key here is that St. Lucia would have a reservoir of talented people to be able to provide the proper on-property inspections of the machines. So you take the VLT machines that we have today, who's going around physically to make sure that they are programmed the way they're supposed to. If we're going to be now offering horse racing internationally online, and in order to be part of that international syndicate, St. Lucia has to have rules of games that are to that standard. But we must provide, as the state, an independent agency to assure everybody that these rules are being adhered to. They're just not on a piece of paper, and we're trying to have them happen, because we certainly would be collecting money on gaming that's taking place outside. So a good example would be, if you take the Kentucky Derby as an example, there's over $100 billion in betting that's done, but all of that betting is not done in Louisville, Kentucky. That's being done in all the different sports bars and betting bars around the world. So there's a syndicate that provides that. In order to be part of that overall international syndicate, the rules that we have to be in keeping with them, and then the government has to show the ability to manage and provide the oversight to ensure that those rules are being enforced. And so there's a separation between the gaming authority and wagering authority and to the actual operator who's responsible for following the rules of the entity. So I'm hoping that I satisfied the Leader of the Opposition's question on those two issues. I thank you.
Honorable members, the question is that the Gaming, Racing and Betting Amendment Act bill be read a second time. I now put the question. As many as are of that opinion, say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Gaming, Racing and Betting Act, Cap 13.13.
Honorable members, we shall go through the bill by way of clauses. Clause 2.
Interpretation.
Clause 2 stands part of the bill. Clause 3.
Amendment of Section 2.
Clause 3 stands part of the bill. Clause 4.
Amendment of Section 3.
Clause 4 stands part of the bill. Clause 5.
Amendment of heading of Part 2.
Clause 5 stands part of the bill. Clause 6.
Amendment of Section 5.
Clause 6 stands part of the bill. Clause 7.
Amendment of Section 6.
Clause 7 stands part of the bill. Clause 8.
Amendment of Section 7.
Clause 8 stands part of the bill. Clause 9.
Insertion of new sections 10A and 10B.
Clause 9 stands part of the bill. Clause 10.
Amendment of Section 11.
Clause 10 stands part of the bill. Clause 11.
Amendment of Section 11A.
Clause 11 stands part of the bill. Clause 12.
Insertion of new sections 12A and 12B.
Clause 12 stands part of the bill. Clause 13.
Amendment of heading of Part 3.
Clause 14 stands part of the bill. Clause 14.
Amendment of Section 13.
Clause 14 stands part of the bill. Clause 15.
Amendment of Section 14.
Clause 15 stands part of the bill. Clause 16.
Amendment of Section 16.
Clause 16 stands part of the bill. Clause 17.
Amendment of Section 19.
Clause 17 stands part of the bill. Clause 18.
Amendment of Section 20.
Clause 18 stands part of the bill. Clause 19.
Amendment of Section 22.
Clause 19 stands part of the bill. Clause 20.
Insertion of new section 23A.
Clause 20 stands part of the bill. Clause 21.
Amendment of Section 25.
Clause 21 stands part of the bill. Clause 22.
Amendment of Section 28.
Clause 22 stands part of the bill. Clause 23.
Amendment of Section 29.
Clause 23 stands part of the bill. Clause 24.
Amendment of Part 4A.
Clause 24 stands part of the bill. Clause 25.
Amendment of Section 30.
Clause 25 stands part of the bill. Clause 26.
Repeal of Section 30B.
Clause 26 stands part of the bill. Clause 27.
Amendment of Section 31.
Clause 27 stands part of the bill. Clause 28.
Insertion of new section 36A.
Clause 28 stands part of the bill. Clause 29.
Substitution of Section 37.
Clause 29 stands part of the bill. Clause 30.
Amendment of Section 40.
Clause 30 stands part of the bill. Clause 41 stands. Clause 41.
Substitution of Section 44B.
Clause 41 stands part of the bill. Clause 42.
Amendment of Section 44C.
Clause 42 stands part of the bill. Clause 43.
Substitution of Section 44D.
Clause 43 stands part of the bill. Clause 44.
Amendment of Section 44E.
Clause 44 stands part of the bill. Clause 45.
Insertion of new Section 45A.
Clause 45 stands part of the bill. Clause 46.
Amendment of Section 49A.
Clause 46 stands part of the bill. Clause 47.
Insertion of new Section 50A.
Clause 47 stands part of the bill. Clause 48.
Amendment of Section 53.
Clause 48 stands part of the bill. Clause 49.
Amendment of Section 55.
Clause 49 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honorable members, the question is that the committee rises and the bill be reported. I now put a question. As many as are of that opinion, say aye. Aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it. Honorable members, I beg to report that the Gaming, Racing and Betting Amendment Bill went through committee stage with no amendments. Honorable Prime Minister.
Mr. Speaker, before we ask that the report of the committee be adopted and the bill read a third time and passed, it would be remiss of me if I forgot to thank the staff of the Attorney General's office and also the Gaming Commission for the number of hours they spent in trying to look at best practices around the world and making these amendments. And I really want to thank them for the weekends and the extra hours they put in to be able to make this happen. Mr. Speaker, I move that the report of the committee be adopted and the bill be read a third time and passed.
Honorable members, the question is that a report of the committee be adopted and that a Gaming, Racing and Betting Amendment Bill be read a third time and passed. I now put a question. As many as are of that opinion, say aye. Aye. As many as are of a contrary opinion, say no. I think the ayes have it. The ayes have it.
Be it enacted by the Queen's Most Excellent Majesty, bearing with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Gaming, Racing and Betting Amendment Act 2019.
Honorable Prime Minister.
Mr. Speaker, I beg to move for the first reading of a bill shortly entitled CARICOM Arrest Warrant Treaty.
CARICOM Arrest Warrant Treaty.
Honorable Prime Minister.
Mr. Speaker, I beg to move for the suspension of Standing Order 48-2 to allow the bill to go through its remaining stages at this sitting.
Honorable members, the question is that Standing Order number 48-2 be suspended in order to allow the Honorable Prime Minister to proceed with the remaining stages of the bill at this sitting. I now put a question. As many as are of that opinion, say aye. Aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it. Leave is granted. Proceed, Honorable Prime Minister.
Mr. Speaker, I beg to move the second reading of a bill shortly entitled CARICOM Arrest Warrant Treaty. The CARICOM Arrest Warrant Treaty Bill incorporates the CARICOM Arrest Warrant Treaty, the treaty in the laws of St. Lucia. The CARICOM Arrest Warrant Treaty has been in existence since 2008 when Antigua and Barbuda, the Republic of Suriname, and Trinidad and Tobago signed on to it. St. Lucia signed the treaty on the 6th of July 2017. The treaty was developed in response to the deficiency of the extradition laws in CARICOM member states. It is meant to provide a more efficient system of surrender of persons among all CARICOM member states. In the treaty, a CARICOM arrest warrant, the warrant can be issued by a judge of the High Court for the arrest and surrender of a person who is reasonably suspected of having committed an offense for which the maximum penalty imprisonment for at least 1 year in the state party that issued the warrant or has fled from justice after a custodial sentence has been imposed for that offense. St. Lucia must designate a central authority to be responsible for the administrative transmission and reception of the CARICOM arrest warrant and other correspondence relating to the warrant according to the treaty. On designation, St. Lucia must notify the Secretary of the Caribbean Community Depository of the designation. St. Lucia must issue the CARICOM arrest warrant in the form and together with the information set out in the treaty, and must deposit with the depository a declaration of the language to be used in the warrant. A request for the surrender of a requested person must be made by a central authority of the issuing state party. When a request is received, St. Lucia as an executing state party, is expected to take necessary coercive measures against the requested person in compliance with the laws of St. Lucia relating to the arrest, detention, and surrender of the requested person. However, provision must be made in the law to empower a competent authority to arrest and detain a requested person under the warrant. The consent of an arrested person must be given to the executing authority in accordance with the laws of St. Lucia. If an arrested person consents to be surrendered, the person must be surrendered within 48 hours of given consent, but if consent is not given, a decision in relation to the surrender of the person must be made within 7 days of the arrest of the person. For considerations, the bill gives the force of law of the treaty and contains the text of the treaty and the schedule of the bill. To give effect to the treaty, the bill contains provisions for a judge of the High Court to be the judicial authority of St. Lucia, and for the minister responsible for national security to designate a central authority by an order published in the Gazette. In addition, in compliance with the treaty, the bill authorizes the judicial authority to issue a CARICOM arrest warrant, and for the warrant to be executed in any district in St. Lucia by a person to whom the execution of the warrant is directed or a police officer. As required by the treaty, the bill contains provisions for the committal of a requested person into custody and the surrender proceedings that would be followed. The Attorney General must surrender the requested person to the issuing state party according to the bill. The recommendations is that the CARICOM arrest warrant treaty bill is required to give effect to the CARICOM arrest warrant treaty to combat cross-border crime and enhance cooperation among law enforcement agencies and security in the CARICOM region. I think that the notes and the descriptions are self-explanatory. Anything that we can do to continue to enhance the security in our region, my government will go the extra length and way to make that happen. So I can certainly highly recommend that we proceed with this amendment as noted. Thank you.
Honorable members, the question is that the CARICOM arrest warrant treaty bill be read a second time. I now put a question. As many as are of that opinion, say aye. Aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it.
An act to give effect to the CARICOM arrest warrant treaty and to provide for related matters.
Honorable members, Clause 2.
Interpretation.
Clause 2 stands part of the bill.
Aye.
Clause 3.
Treaty to have force of law.
Clause 3 stands part of the bill.
Aye.
Clause 4.
Judicial authority.
Clause 4 stands part of the bill.
Aye.
Clause 5.
Designation of central authority.
Clause 5 stands part of the bill.
Aye.
Clause 6.
Arrest and detention.
Clause 6 stands part of the bill.
Aye.
Clause 7.
Committal to custody to await surrender.
Clause 7 stands part of the bill. Clause 8.
Surrender proceedings.
Clause 8 stands part of the bill. Clause 9.
Surrender of requested person.
Clause 9 stands part of the bill. Clause 10.
Amendment of schedule.
Clause 10 stands part of the bill. Clause 11.
Regulations.
Clause 11 stands part of the bill. Schedule.
Sections 2, 3, and 4.
Schedule stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honorable members, the question is that the committee rises and the bill be reported. I now put a question. As many as are of that opinion, say aye. Aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it. Honorable members, I beg to report that the CARICOM arrest warrant treaty bill went through committee stage with no amendments. Honorable Prime Minister.
Mr. Speaker, I move that the report of the committee be adopted and the bill read a third time and passed.
Honorable members, the question is that the report of the committee be adopted and that the CARICOM arrest warrant treaty bill be read a third time and passed. I now put a question. As many as are of that opinion, say aye. As many as are of a contrary opinion, say no. I think the ayes have it. The ayes have it.
Be it enacted by the Queen's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the CARICOM Arrest Warrant Treaty Act 2019.
Honorable Prime Minister.
Mr. Speaker, I beg to move the first reading of a bill shortly entitled Eastern Caribbean Court Judicial Officers' Pensions.
Eastern Caribbean Supreme Court Judicial Officers' Pensions.
Honorable Prime Minister.
Mr. Speaker, I beg to move for the suspension of Standing Order 48-2 to allow the bill to go through its remaining stages at this sitting.
Honorable members, the question is that Standing Order number 42 be suspended in order to allow the Honorable Prime Minister to proceed with the remaining stages of the bill at this sitting. I now put a question. As many as are of that opinion, say aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it. Leave is granted. Proceed, Honorable Prime Minister.
Mr. Speaker, I beg to present a second reading of a bill shortly entitled the Eastern Caribbean Supreme Court Judicial Officers' Pension. The Eastern Caribbean Supreme Court Judicial Officers' Pension Bill provides for the payment of pensions and gratuities to judicial officers of the Eastern Caribbean Supreme Court. From December 1st, 1967, the Pensions Act 15.26 regulated pensions, gratuities, and other allowances to be granted in respect of offices held in the civil service in St. Lucia. The Act defines a pensionable office as an office declared to be a pensionable office by the Governor General by an order. Consequently, on the 6th of January 2003, the Pensionable Officers Order was passed, and Statutory Instrument Number 57 of 2003 Order, and the Chief Justice, Justice of Appeal, and Pusin Judge was declared in the order to be pensionable officers. As a result, the Chief Justice, Justice of Appeal, and Pusin Judge were granted gratuity and pension in accordance with the Act. However, on the 30th of December 1989, the Eastern Caribbean Supreme Court Rates of Pension Judges Act number 12 of 1989, the ECSC Act, was passed to provide the pension for judges of the Eastern Caribbean Supreme Court. In the ECSC Act, provision is made for the computation of a judge's pension. An option is provided in the ECSC Act to a judge to receive a lieu of the full annual pensionable emoluments, a reduced pension at a rate equivalent to 3/4 of the full pensionable emoluments, together with a gratuity equal to 15 times 1/4 of the full pension. A gratuity is payable to a judge's spouse, and there is provision for payment of a widow's pension in the ECSC Act as well. In Appeal number 64 of 2015, the Privy Council interpreted the Act and the ECSC Act and decided that a judicial officer could opt to receive pension and gratuity under the Act or the ECSC Act. To settle the confusion that this has caused, the Eastern Caribbean Supreme Court suggested the enactment of this bill so that the judicial officers are aware of their choices as it relates to the receipt of pension and gratuity. The bill is therefore applicable to judicial officers of the Eastern Caribbean Supreme Court who are assigned to St. Lucia by the Chief Justice. In the bill, a judicial officer is described as a Chief Justice, Justices of Appeal, High Court Judges, and Masters. The decision of the Privy Council is reflected in the bill as provision is made for a person who is a judicial officer when the bill comes into force to choose to receive a pension or gratuity under the Pensions Act, 1526, or the Eastern Caribbean Rate of Pension Judges Act Number 12 of 1989. Notwithstanding, the bill is still applicable to a judicial officer who assumes office for the first time on or after the bill comes into effect. The bill also binds the Crown, which means that the government ministers and departments must comply with the provisions of the bill. According to the bill, pensions and gratuities payable under the bill are charged on and paid out of the consolidated fund. The instances in which a pension can be obtained are also identified in the bill. Consequently, a judicial officer who has served for at least 5 continuous years is eligible for a pension on attaining the mandatory retirement age or the early retirement age specified in the Supreme Court Order Cap 2.01. Whilst the bill requires a judicial officer to retire on attaining the mandatory retirement age, it allows the judicial officer to retire on or after attaining the early retirement age, after giving the Judicial and Legal Service Commission at least 12 months' notice, but the period does not include vacation leave. The bill makes a provision for the new rates for full and prorated pensions for judicial officers and permits a judicial officer to opt to receive a reduced pension and a gratuity in lieu of full pension. There is also provision in the bill for the payment of a pension to the spouse of a judicial officer if the judicial officer dies while in receipt of a pension. In keeping with the bill, pensions will be paid monthly in arrears from the date of retirement and continue to be paid during the lifetime of the judicial officer. A judicial officer who qualifies for a pension and resigns from the office before attaining the early retirement age retirement age will start to receive a pension on attaining that age. If the judicial officer dies before attaining the early retirement age or the retirement age, the spouse of the judicial officer will be entitled to a spouse's pension. If the judicial officer opted for a reduced pension and gratuity in the amount of 2/3 of the reduced pension and gratuity. If a judicial officer dies without leaving a spouse, the gratuity is payable to the estate before the pension is paid to the judicial officer. The Chief Justice must certify that the Judicial and Legal Services Commission that the judicial officer has satisfactorily completed all outstanding judgments and other judicial assignments. Other provisions in the bill make provision for corresponding proportionate increases in pension when the pensionable annulments attached to the office of the judicial officer are increased, and for the payment of gratuities where the length of service does not qualify for pension. Additionally, the bill provides for the payment of a gratuity to the spouse of a judicial officer where the judicial officer is not yet qualified for a pension and dies while holding office, and for the payment of the gratuity and a pension to the spouse of a judicial officer where the judicial officer is qualified for a pension and dies while holding office. If a judicial officer dies while holding office without leaving a spouse, the bill provides for the payment of a gratuity to the estate of the judicial officer. A pension or gratuity cannot be assigned or transferred by the judicial officer. To give effect of the provisions of the bill, the minister responsible for justice is empowered to make regulations. The Eastern Caribbean Supreme Court Rate of Pension Judges Act Number 12 of 1989 is repealed under the bill, saves existing pension rights under the Pension Act of 1526, and the Eastern Caribbean Supreme Court Rate of Pension Judges Act Number 12 of 1989. The Eastern Caribbean Supreme Court Judicial Officers Pension Bill will clarify the issue of pension and gratuity receivable by a judicial officer and should be enacted by Parliament.
Honorable members, the question is that the Eastern Caribbean Supreme Court Judicial Officers Pension Bill be read a second time. I now put the question. As many as are of that opinion, say aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it.
An act to provide for pensions and gratuity payable in respect of the service of judicial officers of the Eastern Caribbean Supreme Courts and for related matters.
Honorable members, we shall proceed by way of clauses and then by parts. Clauses 2 to 4.
Preliminary.
Clauses 2 to 4 stands part of the bill. Part 1, clauses 5 to 15.
Pensions and gratuities.
Part 1, clauses 5 to 15 stands part of the bill. Part 2, clauses 16 to 18.
Miscellaneous.
Part 2, clauses 16 to 18 stands part of the bill. Clause 1.
Short title and commencement.
Clause 1 stands part of the bill. Honorable members, the question is that a committee rises and the bill be reported. I now put the question. As many as are of that opinion, say aye. As many as are of a contrary opinion, say no. I think the ayes have it. The ayes have it. Honorable members, I beg to report that the Eastern Caribbean Supreme Court Judicial Officers Pensions Bill went through committee stage with no amendments. Honorable Prime Minister.
Mr. Speaker, I move that the report of the committee be adopted and the bill read a third time and passed.
Honorable members, the question is that the report of the committee be adopted and that the Eastern Caribbean Supreme Court Judicial Officers Pensions Bill be read a third time and passed. I now put a question. As many as are of that opinion, say aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it.
Be it enacted by the Queen's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Eastern Caribbean Supreme Court Judicial Officers Pension Act 2019. This act shall come into force on a date to be fixed by the Minister by order published in the Gazette.
Honorable Prime Minister.
Speaker, I beg to move for the first reading of a bill shortly entitled Customs Controlled Management Amendment Number 2.
Customs Control and Management Amendment Number 2.
Honorable Prime Minister.
Speaker, I beg for the move for the suspension of Standing Order 48-2 to allow the bill to go through its remaining stages at this sitting.
Honorable members, the question is that Standing Order 48-2 be suspended to allow the Honorable Minister to proceed with the remaining stages of the bill at this sitting. I now put a question. As many as are of that opinion, say aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it. Leave is granted. Proceed, Honorable Prime Minister.
Mr. Speaker, I beg to present the second reading of a bill shortly entitled Customs Control Management and Amendment Number 2. The Customs Control and Amendment 2 bill amends the Customs Control and Management Act 1505, the act to provide for the Advanced Cargo Information System. The Advanced Cargo Information System is a computerized information system created by the United Nations Conference on Trade and Development, UNCTAD, to track conveyances and goods. The Caribbean Community CARICOM Implementing Agency for Crime and Security Impacts, in collaboration with the 10th European Development Fund and the UNCTAD, is facilitating the implementation of ACES in CARICOM member states. It is expected that the regional centralized system will be completely included in the automated system for customs data, ASICUDA, that operates in each member state, so all cargo manifest is electronically submitted to the regional centralized system. The ACES, which is a vital part of the World Customs Organization's SAFE framework of standards, will then assist CARICOM member states to standardize and synchronize electronic cargo information to assist with regional trade. The pilot exercise for the implementation of ACES has been successfully launched in Grenada, St. Vincent, and the Grenadines. This is the first phase towards implementation, which allows for the testing of ACES to ensure a seamless integration of advanced cargo information in support of the import and export of goods and the movement of persons in and out of the member states. Moreover, the collection of cargo information in advance will enable customs authorities to identify high-risk shipments that could threaten the safety and security of the region. The European Union, the donor, has instituted a strict timeline for implementation of ACES and has indicated that July 31st, 2019 is the absolute deadline for all member states to operationalize the system. Failure to observe this deadline will result in unused funds for the project returned to the donor, thereby placing the obligation of the member state to fund the implementation and possibly causing impacts to violate its obligation under the donor agreement that could result in the entire project being determined to be ineligible by the donor, resulting in CARICOM having to repay approximately €600,000. Changes to the Act are therefore urgently required to ensure that CARICOM meets both its commitments to the Conference of Heads and the contractual obligations of the donor. To facilitate the introduction of ACES in St. Lucia, a number of changes must be made to the Customs and Control Management Act, Cap 1505, which regulates importation of exportation of cargo in St. Lucia. It is essential in making changes to the Act to provide for the new terms that will be used in the Act as a result of the amendments to the Act. Therefore, the term advanced cargo information, cargo reporter, conveyance, and impacts are all defined in the Act. Importation is specifically provided for in Part 4 of the Act. As a result, Part 4 of the Act is being amended to require a master or commander of a vessel or aircraft and a cargo reporter to provide the proper officer prior to arrival of departure passenger cargo information that is provided in the schedule inserted in Act under the bill. Non-compliance with this requirement by the master, commander, and cargo reporter will result in the payment of a fine not exceeding $10,000 or imprisonment for 2 years. The amendment of Part 4 of the Act also states that advanced cargo information can only be used for the purposes of the Act and to conduct screening against watch list of cargo on conveyances that are within the regional space. Advanced cargo information must be kept for a period of 7 years and can be shared by the Controller of Customs with the International Criminal Police Organization. The regulation-making power provided to the Minister of Finance under the Act is amended so that the Minister can make regulations to set out the procedure to be used for the reporting and processing of advanced cargo information. Schedule 5 is added in the Act to state that the advanced cargo information to be submitted to the proper officer by the master commander of the cargo reporter. The schedule also contains the time period in which the advanced cargo information must be provided and the entities that can be provided with the advanced cargo information by the Controller of Customs. The passing of the Customs Control and Management Bill will amend the Customs Control and Management Act, Cap 1505, to implement the Advanced Cargo Information System. As members will know, that we passed a similar bill for passengers, the Advanced Passenger Information List. This is also a critical component of legislation to also facilitate the introduction of a single window, which is a program that we're currently undertaking and hope to have implemented very soon. And this certainly will also go a long ways in helping to strengthen the new border control entity that we're going to be introducing shortly. Thank you very much.
Honourable members, the question is that the Custom Control and Management Amendment Number 2 bill be read a second time. I now put the question. As many as are of that opinion, say aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it.
An act to amend the Customs Control and Management Act, Cap 15.05.
Honourable members, Clause 2.
Interpretation.
Clause 2 stands part of the bill. Clause 3.
Amendment of Section 2.
Clause 3 stands part of the bill. Clause 4.
Insertion of new sections 20A and 20B.
Clause 4 stands part of the bill. Clause 5.
Substitution of Section 141.
Clause 5 stands part of the bill. Clause 6.
Insertion of new Schedule 5.
Clause 6 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honorable members, the question is that the committee rises and the bill be reported. I now put the question. As many as are of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Honorable members, I beg to report that the Customs Control and Management Amendment Number 2 bill went through committee stage with no amendments. Honorable Prime Minister.
Mr. Speaker, I move the report of the committee be adopted and the bill be read a third time and passed.
Honorable members, the question is that the report of the committee be adopted and that the Customs Control and Management Amendment Number 2 bill be read a third time and pass. I now put the question. As many as are of that opinion, say aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it.
Be it enacted by the Queen's Most Excellent Majesty, by and with advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Customs Control and Management Amendment Number 2 Act 2019.
Honorable Prime Minister.
Mr. Speaker, I move that the House stand adjourned, sine die.
Honorable members, the question is that this House do stand adjourned, sine die. I now put the question. As many as of that opinion, say aye. As many as of a contrary opinion, say no. I think the ayes have it. The ayes have it. Sitting is adjourned.
Thank you once again for staying with the broadcast. Today's sitting of Parliament saw a number of statutory instruments laid by the respective ministers. A motion by the Honourable Prime Minister and Minister for Finance, Economic Growth, Job Creation, External Affairs and the Public Service, Alan Chancellor. That was be it resolved that Parliament do authorize the Attorney General to make an order to declare that the 2015 supplement to the revised edition of the laws of St. Lucia, as specified in the order, shall come into force on such date as may be appointed by such order as an authoritative version of the law. Number 2, be it resolved that Parliament revokes the Finance Administration Act resolution of Parliament to authorize the Minister for Finance to guarantee borrowing by the St. Lucia Air and Seaports Authority to finance the Hiranore International Airport Redevelopment Project, published as statutory instrument number 94 of 2019. Be it further resolved that Parliament authorizes the Minister for Finance to guarantee a loan in the amount of $202,500,000 EC for the purpose of financing the Hiranore International Airport Redevelopment Project by the St. Lucia Air and Seaports Authority from a syndicate of banks led by the Bank of St. Lucia Limited as follows. Bank of St. Lucia Limited, $58,900,000. First National Bank Limited, $54,500,000. Grenada Cooperative Bank Limited, $40,100,000. Antigua Commercial Bank Limited, $24,500,000. Eastern Caribbean Amalgamated Bank, $24,500,000. Be it further resolved that the loan is repayable over a period of 20 years, inclusive of a grace period of 5 years on the principal payments with interest only paid. B, the interest is payable quarterly from the date of the initial disbursement of the loan amount and is payable at a rate of 5.5% per annum during the grace period of 5 years. C, the interest is payable semi-annually at a rate of up to 5% per annum at the expiry of the grace period of 5 years. D, a commitment fee of 0.75% is payable on the disbursement of the loan. 3. Be it resolved that Parliament authorizes the Minister for Finance to purchase with monies from the Consolidated Fund 401,174 shares in the Republic Financial Holding Limited, which shares are currently held by East Caribbean Financial Holding Company Limited. And 4 bills were laid by the Honorable Prime Minister, that is the Gaming, Racing and Betting Amendment, CARICOM Arrest Warrant Treaty, Eastern Caribbean Supreme Court Judicial Officers Pensions, and Customs Control and Management Amendment number 2. Thank you once again for staying with the broadcast. Until next time.